Welcome everyone to the November workshop for the Junior Faculty Forum. And we have yet another exciting paper to discuss today. Let me first introduce our excellent conveners, Ms. Swati Singh Parmar, who is an assistant professor at Dharamshastra National University in Jabalpur. Dr. Animesh, who is the assistant professor at Xavier's University in Kolkata, and Mr. Prakash, Meena, who is an assistant professor at Delhi University, who is doing examination duties today, so cannot join us, sadly, but he's, like the other two, been doing a lot of work in the background. Thank you for your commitment to the Junior Faculty Forum. Most of you, I see, are our usual regular attendees, but I'll still explain our purpose and mission and format to those of you who have joined for the first time. But before I do that, I would like to introduce our authors and our discussant. We have a co-authored paper today by Assistant Professor Atul Alexander from West Bengal National University of Juridical Sciences, WBNUJS in Kolkata, and Ms. Anushna Mishra, who is a fourth-year student in the same university. Now, you know that we have a rule that we only accept papers from people who are teaching law in South Asia, but obviously students who have co-authored papers with teachers, at least one of the authors have to satisfy the rule, not necessarily both. So we're very pleased to have you both, Atul and Anushna, and also thank you very much for putting your paper forward to workshop it with us. And we are also extremely pleased to have Dr. Surubhi Ranganathan joining us from the Faculty of Law at Cambridge. She's a senior lecturer at King's College, Cambridge, and the Deputy Director of the Lottbach Center of International Law, probably the leading academic institution on international law in the world. Maybe that probably is not merited at all in that sentence. So Surubhi is not only a fantastic scholar of environmental law and international law, but also a really kind and nice person, and just the next in the extremely good series of kind discussants we've had so far. So welcome, and thank you again for your time, Surubhi, for the Junior Faculty Forum. So to go over our objectives yet again, but quickly, for if you're joining us for the first time, the Junior Faculty Forum organizes workshops every month in the first or the second Saturday of every month for work in progress papers. The goal is to provide a forum for workshopping papers, forums that are robust, but also kind and constructive. So while we don't want to pull any punches when it comes to the substance of the paper, we want to make sure that the arguments, the structure, the substance, everything in the paper is top-notch. We also want to be generous and kind. We have started experimenting with allowing people to ask their questions directly by turning their videos on. But if you do, please make sure that you keep the questions precise. I'll remind you again when we open for Q&A. But keep your questions precise, keep them generous, keep them kind, and ask yourself, am I asking this question for what motive? If you're asking the question to show how clever you are, don't ask it. If you're asking the question to help the author, to improve the paper, do ask it, right? That's always a good test to ask the question, to ask any question in a workshop setting. We have other medium-term objectives beyond this workshop to become an association, a union of sorts for early career junior law faculty members. But we will see how all of those things evolve. And if you have ideas, suggestions, please join us. You know, hopefully we aim to become an advocacy forum for working conditions for early career faculty, for more time to do research, for better pay and security, job security, so things like that. But that's all a medium-term agenda, and your buy-in will decide that. So over to the format. I'm going to start, as I often do, with a quick sort of outline of things that I care about as a journal editor in a good paper, with perhaps a few comments to just explain what I think of this paper, and then that will be no more than 5 minutes. The discussant will then take over for the next 10 to 15 minutes. She will give her comments. The authors have a right to reply. They don't have to reply to everything. They can just take all the comments on board, and we'll open up for Q&A, or if there's one or two issues they want to reply to, they will have the opportunity to do that. So last meeting, I believe I explained to you what a good abstract does. So we will put that to one side now, and today I'll talk to you briefly about what I see, what I look for in a paper as an editor. There are 5 broad things. I've discussed this in one of the previous workshops already, but it's useful to reiterate this. The first is whether the question, the research question, is clearly articulated, and there's a clear hypothesis. Why should I read this paper? Or if I invest my time to read this paper, what will I gain in terms of knowledge having read it, right? Because remember, we live in a world where there's so much to read and very little time. So you have to convince the reader and convince them quickly that their time is well spent reading your paper. The abstract does most of that, and look up the previous video for what the abstract needs to do. But the question has to be clear, it has to be precise, and it has to be a question. It cannot be, I will tell you everything I know about topic X, right? That's a textbook. You're not writing a textbook. You're writing an argumentative paper. The second thing I look for in a good paper is its structure, right? Is it well structured? And structure is the thing that makes it easy for the reader to read that paper. So you have to get into the mind of the reader and think about, what does the reader need to know? What is the step that I need to take as an author to make it easier to read? And usually a good structure is show the reader your destination. This is where I'll take you. Tell the reader that upfront, right? And why you need to get there, why it matters, the so what question, right? It's not just where I'll take you, but why you should care about this. And then give them a map, the roadmap that will take them there. Right? So not just the destination, but the exact, precise, argumentative, and evidentiary pathway that you will take to get the reader there. Give them the context. Why does this? All of this work needs to be done quickly in the first 2 or 3 pages to tell the reader quickly what the roadmap is, what the destination is, what is the context, why does this matter? And then follow that structure through, right? The third thing I look for in a paper is its analytic skills, right? Is it well argued? Does it deal with the opposition? Does it engage as a scholarly piece of work, right? You don't want to be polemical. Right? You're not a politician trying to convert me to your party. You're a scholar trying to figure out the truth, right? Doing your best attempt to figure out the truth. If there is no opposition, think about what the best argument against what I'm arguing might be. Articulate that and then deal with that. And if that requires modifying your own position, do that, right? So it has to be, this is what is called rigor, right? This is a key element in every journal article. The fourth is knowledge. You have to have a comprehensive knowledge of all the relevant material, both primary and secondary. You cannot write a paper in ignorance of the literature. And finally, this is the icing on the cake, it's originality, right? You don't want to do something that's already been done. Why would you waste your time and the reader's time? And you have to add to the literature in some way. It need not be an original position to defend. It may be a new way of defending an older position. It may be a new methodology. It may be a new discipline. There are many ways of being original, but you have to add to the literature. It may be modifying an older argument in a small way. So originality need not be fast, but it has to move the debate forward. It has to add to the scholarship. So these are the 5 things I look for in an article. This paper is not an area of my expertise, so I will defer to the expert on that. But the one comment I had, which really stood out to me, it seemed fairly well researched. The knowledge was quite strong, but I'll defer to Surabhi on all of that. The one thing I think the paper needs work on is its structure, which is, although it's parceled out quite well into sections, in fact, the abstract does a better job of telling me what the destination is, what the argumentative map is, but that is actually absent in the paper itself. So you need to do that early on. You need to explain the structure. Your sections need to be tied in together. They sort of appear miraculously, and the reader has to do the hard work to figure out how the sections are interlinked and how you are building upon an argument step by step. You do the work. Show the big map, do signposting. This is what I've told, this is what I will tell you in this section. This is how it fits in with my broader argument. Once you've done the section, this is what I have told you, and this is why the next section will take the next logical step of moving the argument forward, right? So that kind of signposting work, I think, is definitely necessary in the paper. But anyway, I will stop there with that brief outline and pass the baton on to Surabhi for her comments. Thank you, Surabhi, and over to you.
Thanks very much. I'm sorry, I think I just got cut off for the very last minute of what Tarunabh was saying. But let me say, from everything I heard, I endorse it very much. And in fact, some of these things would have been things I would have directly to the paper. So Atul and Anushna, thank you very much for an engaging paper. I'm particularly grateful to have had something interesting to read yesterday, as we were all, I suppose, sitting and just watching election results. It was nice to switch that off for a bit and turn to something that was, again, more to do with international law, what we do. So thank you for that. I think what I'll do is, and this is again building on what Tarunabh has done, is perhaps redescribe to you what I see as the goals of your paper, is what the paper is trying to do, because I find sometimes when a work is in progress, it's quite helpful for the authors to hear about how other people read the nature of the project, right? And after that, I'll talk a little bit about some of the things you could do to maybe, in some cases, push the argument, and in some cases, maybe just refine how you're presenting what you do. Okay. So what I see is the goals of your paper. Essentially, what the paper is doing is it is mapping and evaluating the international law governing transboundary aquifers. And you're doing this in relation to two aspects. One, your paper is keen to locate the law in the material context of these aquifers. So you are thinking a little bit about the features, the physical, the hydrological, etc. features of these aquifers, and you're thinking about some of the contemporary pressures and competing interests that sort of operate in relation to these aquifers. So you're thinking about the tensions between development on the one hand and conservation on the other hand in terms of the industrial model of development, but you're also thinking about distributional issues, which is interests of present generations versus interests of future generations. And a third set of, this is supposed to do with legality. You're also thinking about the tensions between sovereignty and the entire politics of state sovereignty, permanent sovereignty over natural resources, etc., versus community and the idea of community interests, community obligations, obligations of states towards the world as a whole. The paper is identifying these tensions along the way, and then it is looking at how international law addresses these tensions. So here are some of the things that the paper does. One, it seeks to, it tries to identify the rules, right? So you're saying, what are the rules? And here, I think the purpose, the enterprise is to map the rules from the most specific to the least specific. So in some ways, going from treaties to custom to general principles, and also from the hardest law that you can find to softer law or law that may be in development or is progressive development. Here, you identify particularly the work of the International Law Commission, the draft articles on transboundary aquifers, which are specific and annotated because the ILC provides commentaries. They're not, but they're not binding. At the same time, even if they're not binding in themselves, they do have some amount of authority. To some extent, they are a codification of customary international law, and they become influential in other ways to the extent that they are picked up and made the basis for practice by states or by international institutions. So you're focusing on this as the most sort of precise statement that is in existence about how transboundary aquifer should be governed, and you're looking to see the extent to which the rules in the draft articles might actually might come to have binding legal influence. So that's one. You're speaking to some extent to the formal characteristics of the law. What is the law? To what extent is it hard law? To what extent is it soft law or law in development? But you're also interested in analyzing the content of this law. So what is it that this law does? What does it actually provide? And here, particularly, how does it really engage with these tensions, right? These tensions of development versus conservation, sovereignty versus community, present versus future generations. So you're also trying to see how, in addressing these tensions, how these draft articles are drawing on or building on a wider body of international law, building on related treaties or declarations, building on general principles, drawing analogies from contexts like those that have to do with the law of the sea, for example, where again sovereignty versus community becomes a pressing tension, and also how they draw upon possibly interesting new ideas in legal scholarship, and particularly one of the ideas being this reframing of sovereignty as not just about the rights of the state, but also about duties to the community. So sovereignty as trusteeship or sovereignty as custodianship, an idea that has sort of popped up at different points and one could say, in fact, an idea that was co-produced with the idea of the permanent sovereignty of natural resources. So you see both of these ideas emerge and circulate quite a lot in the 1960s and 70s, but an idea that has been pressed much further in more recent literature. And I have in mind the work of my colleague here at Cambridge, A.R. Benvenesti, who looks at sovereignty as trusteeship in the context of actually transboundary water resources. And then I suppose you're also interested to some extent in looking at not just what these articles provide and how they engage with the tensions and how they draw upon or build on a wider body of international law, but also whether and how they speak to practice, which is why I suppose you take up these two examples of Israel-Palestine and India-Pakistan. And overall, what the paper I imagine will do when it's in final form is to give us a picture of the alignments of these articles, both with international law. What are its alignments or disalignments? To what extent is it a reflection of existing law? To what extent is it progressive development? And will give us some of it, a picture of its material alignment. So how does it actually address these tensions, right? So what does it have a slant? If so, what kind of slant is it? Or does it provide an ideal balance? If so, what kind of balance is it? And of course, this is the basis for your final evaluation of what further might need to be, where it needs to improve, what needs to be done. So set out as such, one can see value to the exercise, right? Your baseline assumption is that the law is not clear, and you will clarify what the law is. You focus on the directly applicable set of rules, which you will evaluate with a view to seeing how they can be improved. And moreover, you'll do it in a way that is of course doctrinal. So this is a doctrinal paper, but which is alive to the material context against which these doctrinal decisions have to be made, right? So how does it actually pick up and respond to a whole bunch of tensions that exist in the world? Without sort of suggesting that these are not real tensions or that they don't really exist. These are real and pressing tensions, and so that to some extent they constrain, they act as real pulls or real constraints on the decisions that have to be made. So I would say that for me is what this paper is doing. The challenge then, of course, as for any paper, and this is for all the work that all of us do, is how we execute these projects, right? So once we decide that, okay, my project is going to be a doctrinal project, I'm going to really shine a light on this specific area of international law that I believe has been addressed through a series of rules, but it hasn't been systematically treated in the literature. And I'm going to do that systematic treatment. Then I have to set about thinking, well, what are the things I need to make a compelling paper out of that? And I'm just going to here press some of the points Tarunabh made. I think a few things really matter, right? One is just clarity. So be very clear about the goals. Be very clear, firstly, about what motivates you, right? What moves you to write a paper What is your interest? Why are you interested in transboundary aquifers? What is your interest in exploring the law in relation to that? And then really, what are the specific questions that you're looking at? Be also very clear about your materials. So I've walked through the materials, and it's, I think, quite helpful in general when you're setting out to write a paper. Particularly, this is, I suppose, truer for international law, where materials tend to be quite scattered, is to have a very clear idea about what are the materials you're bringing into conversation and what is their formal status, and also the ways in which you can try to engage with them, what the ways in which they relate to each other, and the ways in which the material speaks to each other. So clarity of goals, motivation, materials, clarity in the use of basic concepts, right? So you're working here to the extent that this is a paper that is about presenting a picture of the law. There has to be a clear account. You have to have a clear account of the sources of the law, both in terms of the moves from specificity to generality and the moves from hardness to softness. What happens in this paper to some extent, so you do, of course, you clearly know your sources, right? But the paper jumps sometimes between using custom, general principles, use cogents in ways that suggests to me that you're treating all of them more or less interchangeable, but of course they're all slightly different things, right? So there's an assertion somewhere where you say, well, these are new principles, or this is progressive development, which might become custom, and then towards the end of the paper we get something to statement to the effect that a lot of this is already custom and some of it is even use cogents, right? So it suggests to me that that needs some clarification is needed, right? What are we talking about? Be clear about also, again, and this is another important thing in a paper like this, which is seeking to provide an overview of the law. The chronology has to be clear, right? So the history can be brief, but it can't be potted. I'll give you one example. You discuss in the middle, so you have an interesting discussion on PSNR, permanent sovereignty over natural resources, but in the middle of this discussion, you mentioned the River Oder case, which is 3 decades before the PSNR, right? That's a case from 1929. So one wonders what happens to the chronology when in something like that. We're talking a lot about the 60s, but suddenly we are drawing on a case as an expression of that principle, which goes back to the 30s, and what that needs to be contextualized. Another example, when you offer right in the beginning a brief review of the developments relating to transboundary aquifers, I was trying to work out for myself what is the organization, what is the principle of organization there, and I couldn't get whether you were trying to organize these developments by date, which would be one way to do it, or developments by the nature of the rules, so whether you were discussing treaties first and then other kinds of law. It seemed to me a mix of both in a way that, again, it became less a clear flow and more slightly stream of consciousness, right? So maybe it's clear to you why the discussion is moving in that order, but it has to be clear to the reader. So essentially, just clarity is very helpful. It's helpful, I think, for the author in writing the paper. The clearer your own account of what your research questions are, what the materials you're using are, what your chronology is, the better the paper you'll write, but also the easier the paper for a reader who might not know, who's not thought about this as much as you have, right? So you've lived with these ideas for much longer. A reader has to be able to make sense of it at first reading, right? Second, and this is again something that Tarunabh talked about, is analysis. And I think one of the things that is really important is what I call analytical tenacity. So you have to stay for a while with whatever it is that you're analyzing, right? When you're discussing a concept, stick with it for a bit. Think about, drill down into it, think about how you explain it, unpack it, assess it. What happens sometimes in this paper, and that is often a function of first drafts, when we have a lot of ideas and we want to put them on the pages, that we end up jumping from one point to another, coming back to a point, the first point later on. It again suggests, it presents a picture of greater confusion than might actually be in your head. So stick with your concepts, work with them. And this is particularly important, I think, for doctrinal work, where what you're doing is you're trying to explain what the law is or something, right? So drill down. When you're explaining to me the draft articles, explain them to me clearly. Tell me their context, tell me about their structure, then work me through the most interesting provisions in it. And you do some of this, but do it with sort of, just sort of do it in a way that you stay with each of these things and unpack them to the extent that you need, right? And this can be very interesting work in itself, right? Piloting a rule can be quite fascinating for any reader, but it has to be done again with the same amount of, it has to be done with care and precision. Which brings me then to the third thing that's important, which is of course precision. So what sometimes a paper might actually be, once you start thinking about it, quite a good paper, but sometimes what undermines it in the view of the reader is if the claims that it makes come across as too sweeping initially, right? When it seems to be overstating what it's doing, or it seems to be drawing on making very general, very vague statements. So for example, let's come back to that one statement I cited earlier when you say many provisions have become custom and some have even become use cogents. Now this has two problems, right? One is that it's too vague. I don't know what are these many things that have become customs and which are those some things that have also become use cogents, but it's also too sweeping because I don't actually know that that's the case, right? I have to be shown that in a precise way. If the same statement, if you were to say principle X and Y have become customary international law and principle Z is actually accepted as use cogents, that would be more specific, right? It would also avoid a kind of vague overstatement. But also when you say international law has not dealt with transboundary aquifers at all, and then you proceed to actually list a whole bunch of things that do speak to transboundary aquifers, then again it becomes a general statement that is not even borne out by what you want to do in your own paper, right? So it's just precision of claims. Another example, when you say with globalization, the problems of transboundary aquifers have become more acute. Again, that's a general statement. I'm sure that's true at an abstract level, right? But you have to tell me what is. So, it can't be that, oh yes, globalization has caused all these problems. Again, the care with which a paper is crafted will be seen as how, if you can turn that into a more specific account of the challenges that confront transboundary aquifers, right? That's also helpful work for the reader. It tells us why we should care about this problem, right? What are the tensions that govern this problem that that the law is trying to resolve? So it makes us really think about the situation. It does what you are trying to do, what you suggest is important, which is to really think with aquifers as material things and not just as some vague abstract idea, right? So you do in your paper point to differences between aquifers, point to the fact that one aquifer might be quite different from another, the physicality of aquifers and so on. Again, so therefore being more specific about the nature of the tensions, the nature of the problems would help us care much more, right? And I must say, I face this a lot. I work on the law of the sea to an extent, and one of my challenges is always to make the reader care about places that are not visible, right? People don't think about these places, they don't see these places. So specificity really helps there. A third thing about precision is really just selection and use of materials, right? And how you arrange materials. So you have to think about what is not just what your material is, but what is the basis on which you're selecting materials, how are you using materials, when you're choosing to talk about cases, why are you choosing these particular cases? In your case, when you choose these two examples of practice, why these two and what are you trying to do with them, right? So are they just there to provide illustration of your points? If so, make that clear. Or are these two fraught issues that help to do something to your argument? If so, then work with them again, do much more with them. Right now, they're sort of there, but it's not clear to me how they fit into or feed into the rest of the argument. So again, an author has a lot of sort of, it's when you write a paper, in a way, you build a world. You build a world by telling us what is relevant, what we should think about as the relevant material of this world. If you are choosing to bring case-specific treaties or instruments or cases or practice into the paper, then think about why and show us why they matter, right? What they do for your argument. Now, another thing is precision, not just of the kinds of questions you ask, but also what you want to do in terms of recommendations. So my sense of this paper was that the build-up is towards trying to say something at the end about where the law should go or needs to go, where you hope it will go. Now that is again one way to do it is the generic way, right? It doesn't leave the reader very much because you're just sort of saying, well, the law needs to be better, it needs to manage these tensions better. You leave it there. The other thing to do is to turn that into a series of more focused questions. And here, actually, with transboundary aquifers, there are some focused questions you can ask, right? These are questions that, in a way, the International Law Commission already alerts us to because it leaves these questions open. One question is, of course, the formal question. Should these articles at some point become the basis for a convention? rather than remain articles? Or will they have more influence or become more operational in practice if they remain articles? This is a question that has often been asked with respect to other codification exercises of the International Law Commission. It's a very, very broad question with respect to the articles on state responsibility, where that debate has been ongoing for the last decade or more. So it's a good question to ask because it helps you think through the ways in which a codification exercise might come to have influence. It also helps you think about the ways in which, if the articles are turned into a convention, and that gives us an opportunity to revisit some of their text, what textual improvements might be, or what conceptual improvements might be put in place during the phase of transposing these articles into the form of a treaty. Another question that you could ask, another set of questions you could ask is really, and it's a question that clearly interests you because you mentioned it once or twice, is dispute settlement. To what extent? So this is the International Law Commission leaves the question of how to settle disputes open. It doesn't have a specific provision in the draft articles, but it's also a question, you raise the question about, well, to what extent can the uptake by these questions around transboundary aquifers by courts in the context of disputes between two states lead to more generally applicable law, right? And that's another interesting question to us. So you can think about the ways in which dispute settlement might contribute to the development of the law in this field. You could also think about maybe another direction in which you could push your recommendations is, since you start with thinking about material tensions, and you find that in some cases these tensions are addressed better, in other cases worse, you might think more specifically with what might be better ways of addressing these tensions, right? So again, the sovereignty as trusteeship idea is an interesting one because it sort of tries to overcome the tension between sovereignty and community by suggesting that sovereignty itself should be relativized as a concept. So build on that. Say you might be able to do more with that at the end. Then another set of things to think about is, and Tarunabh talked about this, is structure and organization, right? So one is, of course, to work out the paper as a whole via sections and subsections, which you do, but it's also worth thinking about the distribution of the load that these sections carry and how you organize your points within sections, right? So one thumb rules that I found quite helpful is, one is make sure that the section is, firstly, think about flow, right? So again, if you were reading a paper for the first time, think about what would make sense to you. Are your points flowing? Is there a natural flow in a direction that you would expect? Secondly, how are you sort of breaking up your points into paragraphs? Usually it's a good idea to think about each paragraph as moving the argument along, right? It's not that if the reason you break up something into two paragraphs is because the first paragraph might emphasize something and the second paragraph might emphasize something else. There's no point in having two paragraphs if they're both saying the same thing. And then micro-organization, organize your points within a paragraph. Same thing, sentences must do this constant work of moving things along, right? So there's no point in having a paragraph that is entirely circular. It doesn't take us anywhere. It's good to have something that keeps moving the argument, especially in now that if you're writing a shortish paper, 8,000 to 10,000 words, you need to make sure that your words are being put to good use. You're not repeating yourself. You're doing you're making each of your words count, right? And then, which brings us to, of course, style. So a few things. I think one of the things I found interesting, I just didn't know why you were doing this, was why commas are your preferred punctuation to full stops. So there were some sentences that became really long and they were punctuated by lots of commas. Consider breaking those up, right? So one of the things I used to be told a lot as well, and I still get told, is that I have very, very long sentences. So I keep reminding myself that the ideal rule is really a mixture of short and long sentences. Some sentences are naturally going to be long sentences, but it's quite nice to intersperse them with short sentences, which again make the readability of something much better. Think about what acronyms you need and which ones you don't need. So if this paper, for example, is to be submitted to an international law journal, now I'm really thinking as an international law journal editor, then having IL as an acronym is not useful, right? I mean, that's pretty much the substance of what the journal does. So you can talk, and also there's no point in introducing an acronym if you're not really going to use it, if it's not doing very much for you thereafter, it's not coming back again, then it just turns something that's quite readable into a clutter of slightly technical sounding terms which don't actually mean anything. IL is not a term. Don't use jargon for the heck of it, and especially not when it doesn't fit. So there was a reference to Grun norm somewhere, which is, reality articles are not they're not the groom norm. And that just becomes, not only does it become a necessary jargon, but it also becomes misleading jargon because it suggests you're claiming a status for a certain kind of law, which it does not have. And then attention, and this is quite, it's a general thing really for everyone listening in, and I think it has begun to matter more and more to me as an editor, but also as an author, is really attention to the choice of terms. What are the visual images that you're trying to create when you choose to use a certain word as opposed to another word? So for example, at one point you talk about treaties being carved out on a certain topic, right? Now, instead, why, to me, the word carved, the phrase carved out suggests something quite different from just saying two treaties were adopted on a topic. By carved out, it seems to me that you're suggesting that they were sort of carefully removed from a larger body of law, or this topic was carefully removed from a broader body of law and turned into two specific treaties. In other words, you're saying something about fragmentation, perhaps. So it creates a different visual image from if you would simply say that these two treaties were adopted, which would be absolutely the fine thing to say. Think about what these words are doing, right? These can be quite powerful ways of doing quite a lot with very few words if the words are chosen carefully. Then they again turn the paper, they make quite a difference to the paper's readability, especially in the eyes of an editor who's sitting with a red pencil and looking for these things. Footnoting, I'm not going to go into. I think when a paper is in a work in progress, we all leave footnotes, to be worked at later. But again, it's one of those things when you actually submit to a journal. Again, it can show care and crafting, right? So care and crafting can be quite important. It's not the most important thing about a paper is its ideas, the research, the argument, but the care with which it's done communicates something, perhaps even in just a very subliminal way, to the editor. It suggests that time has been spent on this paper, right? That this is a paper that is the work that reveals a certain authorial commitment. And so that sort of thing is important for when it reaches the point of submission. Again, maybe once I finish speaking, you could say a little bit more about this thing about sovereignty, your own perception of sovereignty as responsibility, which I think is a genuinely very promising element in the paper. It's something worth pushing to pushing further. So you can unpack that, think about the origins of the idea, to think about its applications across a range of contexts that are relevant to transboundary aquifers. So shared use of natural resources, shared use of water courses, etc. today. And maybe that's one place where more reading and looking at the literature that has dealt with this topic might be useful. Finally, and this is again a general thing for everyone who's interested in international legal research. Just a week ago or so, a colleague of mine at Tel Aviv, Eliav Leiblich, has created a really excellent document. It's called How to Do Research in International Law, which is it's a document. It's on SSRN, and I suggest everyone sort of downloads it, keeps a copy, because it does two things. One, it provides a very handy guide to finding and using research material, right? So if you're starting out with a paper, any paper in international law, and you want a handy survey of where to find various kinds of primary materials, where to find various kinds of secondary materials, then he provides useful lists. But he also does another thing, and that which is something we could have discussed, but I won't, that could very well be a whole session in itself, so I won't do that, which is we could talk about different kinds of projects, right? So one of the things we could have talked about today is what are the different ways in which we might approach this question of transboundary aquifers. So there's the kind of doctrinal project, which is what this paper is doing, but then there are also a more explicitly normative project, or more explicitly critical project, or more explicitly empirical project, and all of those would be different. They would all be within international law, but they would be asking slightly different questions and they would all be slightly different ways of getting to the ends that you are interested in. So in the interest of time, I'm not going to do that now, but Eliav spends some time sort of setting out what are the different kinds of research questions people can ask around similar themes, and that's quite useful to look at. So I'm going to stop here. Thank you very much again for, as I said, for giving me something fun to read during election season, and over to everyone else now.
Well, Surabhi, thank you so much for that extremely careful and extremely thoughtful set of comments. And for our participants, um, we're trying, the point of the workshop is not just to learn about the topic. In some ways, that's secondary. We're learning not just how to write, but also, how to chair, how to comment, how to respond to comments and criticism, right, without defensiveness. So I'm sure Atul and Anushna will do that. But just notice the generosity and the care with which Surabhi spent her time, by the way, for no pay, right? So there is no reward in giving comments and review except a sense of duty, of citizenship, of collegiality, that you owe this to your vocation. Right? So always remember as an author that the reviewer, even an unkind reviewer, so Surabhi is extremely kind, but even an unkind, ungenerous reviewer is doing you a service. They're taking their time to give you something that they don't have to, and many people refuse to undertake this. So that's sort of extremely of course, we want this to be done kindly, but when we are probably the only profession that is organized around criticism, right? We invite, well, apart from politics, I suppose, right? Politics and the academy are the two professions that invite criticism, right? And are based on criticism, and criticism hurts. We have evolved for millennia, right, to not like criticism. So it's a defensive reaction as an author is natural, but it must be overcome by the recognition that the reviewer is doing you a kindness. It's the kindness of tough love sometimes, right? So I just want to pick up and amplify just a couple of things that Surabhi very helpfully spread out in the context of this paper, and then I'll pass on to authors. So my one sense I came away with when I first read the paper was that it, not as much as I have seen, but there was a sense of advocacy. The paper felt like a moot court paper that has been developed into an article. I don't know if that is the actual history of the paper or not, but there's a difference between writing a brief and writing an intellectual argument, which a lot of things Surabhi touched upon, right? The flow was missing, the sense of sort of structure was missing. So all of those things you can do. The research was fantastic, I thought, but obviously Surabhi's given you more references that you should look up. But one final thing I will just mention as a footnote to what Surabhi said at the end about the different types of enterprises, right? She's told you many things that this paper could do, right? Or you could do, right? The only footnote I would add is that remember that this is one paper, and there's only so much one journal article, 10,000 words, can feasibly do. So, if you are going to do normative work, but that requires a lot of doctrinal work first, leave that for the next paper. It's much better not to do it at all in a paper than to do it in a rushed way towards the end, right? Just keep it a straightforward, descriptive doctrinal paper, which can still be original, right? So, what I take from Surabhi's comments in your paper is the section on legal doctrine, right? You could say why that's original. I suppose the claims have to be that the law is unclear and developing in this area, that the scholarship has not put it together. You have to obviously show what existing scholarship has done, what you're adding to that. And to that mind, the hardness, softness distinction that Surabhi made and the generality, specificity distinction will be so important in showing why the emerging norms are softer or whatever, right? So I'm not an expert, but anyway, so those are the comments for you. If you can take 5-10 minutes to respond to any part of it that you want, that's over to you, Atul and Anushna, and you can take your time in terms of dividing in the way you want, and then we will open up for Q&A. And I'll start keeping a queue now, so participants can just use the raised hand feature to leave a raised hand if you have a question. Or over to you, Atul and Anushna.
So firstly, I would like to thank Khaitan sir and Surubhi Ranganathan for this opportunity, and I'd like to thank Surabhi in particular for providing some constructive comments on my paper. Appreciate it, ma'am. Firstly, with regard to when we undertook this topic to write a paper on, the first hurdle or roadblock that we faced was there was very limited literature on the subject. It was only in the year 2008 the ILC came up with a report on transboundary aquifers, and unfortunately, as ma'am pointed out, it has not translated into convention. That is because only 38 states are, have agreed to this particular ILC draft. That is one. And secondly, the second difficulty that we faced was most of the laws with regard to environmental regime itself is soft laws. Unlike other regimes like human rights, humanitarian law, etc., environmental law regime operates based on soft law. So we found that very difficult to align it chronological. So you have on the one hand you have UNGA resolutions talking about a specific aspect. On the other hand, you have a protocol which more or less is more regional in context, and most of these regional conventions are European conventions, and that is one that particular aspect we have not addressed in the paper. But this particular topic that we have taken is I think it's an emerging field. So in that regard, we found it very difficult to access literature on the topic. And if I'm right, last year there was a paper in this Max Planck yearbook of United Nations law. That was the paper on transboundary aquifers. Except that I did not find a comprehensive paper on the particular subject matter, except for the fact that all those papers talked about extensively on the convention per se. So we thought of, highlighting firstly the role of soft laws, the role of soft laws in progressive development of international law. And we chose this particular title, General Principles of Law, solely because the ILC is working on this particular topic. Recently, ILC has come up with, I think, two draft conclusions on the general principles of law. So essentially, we are focusing on general principles of international law rather than general principles of law as such, which is predominantly domestic in nature. So in international law, there are only few principles like sustainable development, no harm rule, sovereignty principle, etc. So firstly, we face this challenge wherein the laws are scattered with regard to this particular subject matter. One. Secondly, the literature on the subject is very limited since it's mostly soft laws and the enforcement happens essentially at a domestic forum. And thirdly, with regard to the literature in hand, Sir was pointing about analytics. So with regard to the literature, we found it very difficult to get an objective literature, especially when it came to Israel-Palestine transboundary aquifers, the conflict. Most of the writings were in favor of Israel. I'm not going into why, but I feel there was a larger sense of international politics there. So we have not deliberated much into those aspects, the aspect of the interplay between international politics and international law. So we are not touched upon those aspects, but more or less we came to know that most of this transboundary aquifers dispute is more in the context of international politics more than law. So with regard to international law, the jurisprudence is very, very minuscule, and we try to amplify the existing literature with regard to the same. And with regard to the materials, yeah, again, we found, and another very good point which will definitely add to our paper is with regard to the question of courts. With regard to dispute settlement, at least at the international environmental law, at that particular, with regard to that, there is no specific dispute settlement forum like other branches of international law. So that is one challenge that requires to be addressed. Most of the laws are soft laws. And this particular point has been highlighted in one of the papers, which I apparently happened to read by, I think, Dupy, professor by the name Mary Dupy. I think from University of Paris. She has specifically talked about this aspect of soft laws in international environmental regime. So it became very hard on, at least for us to give a very pressing point on some of the issues. Like, for instance, a very pertinent point that was raised was permanent sovereignty over natural resource versus sovereignty. We could hardly find any cases with regard to the same, except for few scattered cases with regard to sovereignty on the one hand and PSNR. And we in this paper we also try to highlight this paradox. On the one hand, the ILC draft talks about sovereignty, and if I'm right, in Article 3, whereas in the preamble it talks about the principle of shared resources. This is a kind of dichotomy. I think that is largely because of political interest. So we did not go into the political aspect. We strictly try to stick on to the international law aspect. And with regard to the contemporary relevance of this particular paper, with sir, you had also highlighted in the abstract that is required why we have taken this paper. One, there is very sparse or very scarce literature on this particular topic. One, so we wanted to highlight one aspect that was covered in the paper was the India-Pakistan although there is no particular treaty with regard to India-Pakistan on transboundary aquifers or a bilateral treaty per se, but one of the suggestions that I think I've not added that in the conclusion is we need to rephrase or reorient this Indus Water Treaty that was signed in the year 1960 between India and Pakistan. The language of the treaty is silent on the issue of transboundary aquifers, if I am right. So most of the treaties in international law with regard to water dispute talk about surface water. You have Helsinki Convention, the 97 non-navigable use of water course. But it was only in the year 2008, although not a convention, a draft article came about. But the irony is, although some of these principles are customary law, the irony is there is no sufficient state practice. This is something which we were able to identify. There are hardly 38 states, but we say it's a customary practice. I say it's a customary practice because that is what the scholars articulate. But with 38 states, I'm not sure about that. And customary practice in some of these principles, like sustainable development, no harm rule, I would say it's a kind of acquired thing. So we acquire these principles from other environmental law treaty, and we supplant that to the 2008 draft, and we say it's a customary law. In the context of customary international law vis-a-vis transboundary aquifers, customary international law has not developed as such. Maybe one might argue accelerated custom in the context of environmental regime, but it's too early to say that. So we had to work through this paper for a span of 3 months. Of course, this is the first draft. We'll definitely add the points, valuable points. All those points are really good. Especially the structure of the paper. I understand with my limited knowledge that we have not worked much on the structure and style of the paper. We'll take all these comments and we'll incorporate that in our paper. And of course, the points that you had suggested are really useful for the future paper that we are working on. So much appreciated. Thank you.
Thank you very much, Atul. Well, first, it's everybody needs to workshop their papers. Even authors who have been in the academy for 50 years and written 20 books need to workshop papers. So it's not just, we all need an outsider's perspective, a different person's perspective to tell us how to improve it. So don't think that, because you're early career scholars that you've made these mistakes. Everybody makes them. So thank you for your very gracious response. I want to say two quick things, invite Surabhi and then start taking questions. The first thought I have is that, I got a bit worried when you said you will take on the question of enforcement. And, these are all obviously things for Surabhi to say more authoritatively. It's entirely legitimate, even perhaps desirable, that you signal that these issues concern this paper, flag them, but bracket them off. Because if you try to do too many things in one paper, then you'll end up doing very little, right? So say, in this paper, the focus is on norms. Enforcement is a huge issue because there is no implementation, adjudication, dispute resolution body, internationally, whatever. So tell the reader you know that's an issue to be dealt with later, right? Or what should be done about this to be dealt with later. What I'm saying is bracketing is a very good practice to keep, Surabhi said something about analytic tenacity, and that requires focus and depth. So that's always a virtue in the academy, depth over breadth, right? Focus and narrow, go deeper as you can. That's sort of one thought. The second thought was a lot of the things you have said now about the choice of this topic. It'll make so much more sense to have them explicit in the paper that this is an area where the law is in flux. This is an area where there's very little material. Don't say there's nothing, right? If there's 3 papers, say there are 3 papers. Tell them what they do. So that is what I meant by originality. There's a gap in the scholarship that you are filling with this paper. Right? So don't keep those motivations in your mind. Spell them out in the paper. So, do you have quick 2-minute response before we start taking?
Yeah, just a couple of things. So one is I entirely agree that I think it's usually a bad idea for the same paper to want to be doctrinal and normative and empirical, because it just becomes a mishmash, right? But what might be good is towards the end when you're saying, this is where you can do the work of even setting up perhaps to the reader what the rest of your work is going to be, right? So you say, here are important questions that emerge that deserve to be looked into further, that haven't been looked into. And that leaves it's one way you can signify your own mastery of where where further work needs to be done, right? So that's not the worst idea in the world. It's better than maybe saying something like, oh well, yes, we hope things will get better, because you can then say a little bit about what we need to go into that. But more importantly, 2 other things. One is, I should have actually mentioned this. So I found it interesting that you were very right to pinpoint the fact that a lot of the law that exists has to do with surface water and not with underground water, not with transboundary aquifers. I think it might be quite interesting, and again, this is part of doctrinal analysis, is to say where the analogies or the disanalogies might be, right? So I found it interesting. I was reading the draft articles of the RC yesterday, is that they do make these actual analogies, right? So to some extent, they're drawing upon the law of the sea. They're thinking about analogies of potential disanalogies with things like the continental shelf and transboundary aquifers. Again, it might be worth, in your case, to think about why the depth makes a difference, right? So this is actually quite an interesting thing in a lot of fields, to think about the ways in which things that might resemble each other superficially, the transboundary water might actually work differently when we're talking about transboundary water in terms of rivers versus transboundary water in terms of, and why therefore the principles of the one do not directly apply to the other, right? Or cannot be directly analogized to the other. And the second thing, and this is again really quickly, is when you're looking for literature. So I know this is always a problem, right? It's very hard to find often literature on point on the very specific theme. But again, think about literature that has to do broadly with the same set of issues that actually does speak to some of your interests, right? So literature on transboundary natural resources per se, literature on transboundary oil, literature on transboundary water cooperation. These are all, they're not irrelevant bodies of literature, and it's worth seeing how some of the ideas that you're interested in yourself may have already been pushed in this literature as well. If nothing else, it provides you also with a bank of material that you can use when you're trying to push an argument in a certain direction vis-a-vis transboundary aquifers, saying here's an approach that is taken vis-a-vis oil, for example, right? That might prove useful. So that's what I say.
Thank you very much, Surabhi. So we'll start taking questions now. The same rules apply: precision and kindness. Gagan.
Can I give some observations instead of questions? Is that allowed?
That's fine, Gagan. Just keep them
Sure. Okay, sure. Within a minute, I'll just finish the things. I need to disclose that I'm not in this international law and this, whatever the theme of the paper is, it's not my area of expertise. So I'll be making some small suggestions or observations on the structure of the paper and the research methodology and such kind of things. So one thing, I think it was Surubhi who was doing the observations for the paper. Before that, I need to tell the paper is good as a first draft, and can get improved. I have to tell it. Then she was telling about the vagueness and specificity. So when you come across the Wikipedia, like if someone has made an edit, like there are many somethings, some kind of vague statements. The editors come and put it where, when, cited, something like that. So that gives an idea. So about coming to the structure and that thing, what Tarun was saying, I have a suggestion there. What we can do as authors is that before starting a paper, let's have a structure like sections, subsections, and have a narration style, like how we start and how we are going about. Even within one single paragraph, what are the small ideas we are going, like in bullet points, just keywords. Then we can expand those keywords into sentences. That, like, that is something I've been following and it's been really helpful. One more thing about the long sentences. Usually it's always better to cut short the long sentences to shorter ones. But at times, even if the sentences are long, maybe we can use proper punctuations. And if we are employing the punctuations properly, I think the sentences will really make a lot of sense. This is something I noticed with some of the articles written by Gautam Bhatia, because he's one author I usually keep on reading. One more thing is, like, yeah, that's it. If I have something else, it is going beyond the scope of this thing. So Tarun, thank you so much for providing an opportunity to make my observations. Yeah, just one more observation is that when it comes to the writing style and that punctuations and everything, there is one classic book called Elements of Style, which is it's a really old book written by probably Oliver Strunk. It's available free. I think that is a very good book for any researcher to refer if we want to polish our language. Not really about research, but about the presentation skills. So that's it from my side, Tarun. Thank you so much for providing an opportunity.
Thank you very much, Gagan. Next is Katerina. Oh, by the way, once you've asked your question, if you can just in the chat box tell us who you are, that'll be useful. Katerina, let me see if I can unmute you. Yeah, you should be able to speak now. Yeah.
Good afternoon. Listen me?
Yes, I can. Yes, go on, Katerina.
Okay. In my opinion, I discuss about the development after the 2030 agenda. 10 years after the ONU resolution, the application of the human right to water and the guarantee of universal access continue to be disregarded. 4 years after the launch of the 2030 agenda, only 1 in 5 countries guarantees access to water, with a coverage of less than 95% of the population, but none yet guarantees access to water at the minimum vital level as human rights. In the absence of a binding instrument of international law which guarantee the human right to water, Comitato Italiano Contratto Mondiale sull'Acqua, Italian Committee on the World Contract on Water, proposed to the cities to adopt a charter of cities for the human rights to water, which it includes some commitments and good practice to promote the realization of universal access to water as a human right. Thanks.
Thank you, Katerina. So Atul, I suspect the suggestion there is that the literature on the right to water may also have some bearing on the question of transnational aquifers. Again, not an expert, but it might be useful to look into that. So not passing any of these questions to you for reply because they are helpful references or suggestions so far rather than questions. Next, we have Nishtha. Thank you, Katerina. Again, in the chat box, if you can tell us who you are, that would be great. Nishtha.
Yeah, hi, good evening. Just wanted to say thank you for the paper. It was actually quite an interesting read. This is the first time that I'm coming across this idea. So I don't think I have much to say about the content. per se because I'm not aware of it, but just two very small suggestions that I had was that I think as a person who had not read about this earlier, it would be helpful if you could introduce the definition of transboundary aquifers that you as authors are going to be taking as the baseline going forward. Because I think it was only on the third page that you alluded to a definition, and then going forward on the fourth page is where you say that such a such treaty defines it as such. But I am not sure what you as authors are limiting transboundary aquifers to mean, right? So I think that would just at the outset, if you could just state the definition, it would be really helpful for the reader going forward. Secondly, and I think a couple of people have flagged this, right? Both Dr. Gagan as well as Dr. Ranganathan. But the sentences should be shorter, but I also noticed that each sentence, this like, although it was very long, was also introducing multiple ideas within the same sentence, right? So along with being short sentences, if you could also just introduce new ideas in maybe new paragraphs or different sentences, it would be easier to read. Because what happened was that I started reading with a certain idea in mind, and by the end of the sentence, I wasn't sure what I was reading, right? So I think those are the only two suggestions that I had in mind just for ease of reading, especially for someone who's not coming from this background, right? I don't have general background over international law either, other than, you know, what we've read in law school. So I think just these two suggestions.
Thank you very much, Nishtha. And now, after your comments and Surabhi's comments, and I think Gagan's comments as well on style, that's not a feature that we have focused on a lot in this workshop, but maybe it'll be useful to start bringing that to the fore as well. And again, as an editor, especially from Indian, South Asian scholars where English is not the first language, that is an abiding issue. You know, it doesn't matter how good your substance is. So this is not so much to your paper in particular, because I thought that, you know, there was some issues with style, but it was largely sort of communicating directly and it was easy to read. But I've come across papers that are extremely complicated, and there is a sense amongst some, especially younger academics, that in order to sound clever, you need to write in a complicated manner and use a lot of jargon. The truth is exactly the opposite. The more complex the idea, the harder you have to work to communicate it simply. Simplicity is a virtue. Jargon makes things, so don't use fancy words, don't use jargon. If you know two words for the same idea, use a simpler word, unless it's a term of art. Shorter sentences are usually good, unless it's merited. Direct voice is better than passive voice. So all of those things, you know, just make readability so much easier. So plain English, not decorated, you know, you're not writing a work of literature. And even if you were, I think even a work of literature is best when it's simpler. But anyway, simplicity in communication is a virtue, and you know, complexity of ideas with simple communication is sort of the holy grail of academic writing. Okay, so next in the queue we have Aditya. Let me try to see if I can unmute you. Yes, over to you, Aditya.
Hi, good evening. My name is Aditya. I'm a PhD scholar in international law from South Asian University. Thanks for the paper. I think it is a very good paper, but there are certain points which have been reiterated by Surabhi, and there are a few points which I like to highlight. So the first point was talking about the draft articles, right? I think it would be better that if you can provide some reference to the authoritative value of draft articles, because it is very important that where do you locate draft articles in the sources of international law, whether under treaty, it will not come under treaty. It can only come under as reiterations of customary international law principles. So there are 2 or 3 articles available on the authoritative value of draft articles, because the last codification convention, which ILC did, was back in 2005. After 2005, there has not been any convention which has been codified based on the work of ILC. The next point which I would like to highlight is the transboundary sharing of water courses. One of the basic principles is the principle of cooperation. So I think you need to incorporate the principle of cooperation and principle of good faith. And for these two, the best reference would be United Nations Friendly Relations Declaration. There has been a new book which has come, which has been edited by George Vinuels. That book has 15 chapters. Now, 2 chapters in that book is dedicated to the principle of good faith and the principle of cooperation under international law. There is another chapter on international economic law in the same book where they discuss about principle of PSNR, which you have also referred. And so it is very much important to distinguish between whether you are referring to the principle of PSNR from the perspectives of people's rights, or whether you are referring to the principle of PSNR from the perspective of rights of the states. And the other point which I would like to say is, now you talked about that the ILC is currently doing work on general principles of law, but I did not find references that how do you identify the general principles of international law, or so are you talking about general principles of domestic law or general principles of international law? Maybe a footnote here and there on this can also be helpful. Thank you, sir. Thank you for that.
Thank you very much, Aditya. Yeah, and I think you probably need to rethink your title as well once the paper is revised and once you know precisely what your focus is. So there's a lot for you to take away, Atul and Anushka. And
can I respond to that?
Yeah, of course, I'll give you a moment. But I just want to say before then that that Atul and Anushka, that often in workshops one can feel because the time is limited and because the point of the workshop is to improve the paper, what gets highlighted is what's wrong with it, right? And it's often the case that early career scholars, when they workshop something, come away with the feeling that I just completely messed that up. That was so bad. I hope that you're not going to go away from this workshop with that feeling, right? Because I think one of our questions from the floor was preambled by how good the paper is. It's certainly a very well-researched, interesting paper where the hard work is visible. It's a topic that a lot of people don't normally think of. Congratulations on picking up a good topic. So don't, before you reply, don't go away thinking all we have done is criticize it and the paper must be bad. That's absolutely not the case. It's a very good first draft. It of course needs a lot of work, and I would recommend that once you revise the paper in light of the comments you have received today, I would workshop it again. Probably not at the JFF because we have many others in queue, but maybe at your university, maybe with some friends, form a circle of friends where you workshop each other's papers. But I try to workshop every paper before publication at least 5 times, preferably 10 to 15 times. But it's a scarce resource, right? It's a scarce resource that sadly in our world is more easily available the higher up you are in the academic hierarchy, right? So you need it the most when you're an early career scholar, but the space is least available at that time, right? So you have to create your own space. So I would strongly recommend that. But take a few minutes now to respond to any part of the comments that you might want, and then we will close.
Can I just jump in to say exactly this, that I have never written a paper that hasn't gone through multiple rounds of revision, through drafting. I end up redrafting sometimes before I ever submit several times. It goes through multiple workshops. People will often tell me that so this is not work that ever stops, right? Academically, the pleasure of being an academic is a lot of people reading your work, agreeing with you sometimes, disagreeing with you quite often, working out your ideas. Ideas work themselves pure. If we could write first draft straight off, we wouldn't be academics, right? We'd be some other kind of career where words are easier to come. So that it's, please don't see any of us. If I was presenting a paper now, I expect I'd be getting the same kinds of comments saying, you need to clarify this, that's not clear. That's just standard, right? I mean, this is how work goes from draft to publication.
Yes, Atul. Thank you, Surubhi.
With regard to Aditya's point on good faith, I think we have covered that point briefly in our paper, wherein we discuss the provision under VCLT Article 26, if I'm right. Although we have not discussed that in detail, we will take your point on board. We'll add a few cases from the ICJ, like the nuclear test case, wherein the court explicitly talked about the principle of good faith. Now, this particular doctrine comes into play when the treaties or the customary international law is silent on a specific aspect. So, good faith obligation, which is an independent obligation, a state can invoke, to fulfill the obligation in good faith. Now, with regard to the second point, a very good point that you raised, Aditya, on the ILC's work. Where does ILC's work fit in the scheme of things when it comes to the sources? So, if you ask me personally, I feel it comes under the teaching of scholars. Teaching of scholars, which is also one of the sources under Article 38. Of course, it plays a role in the formation of customary international law. But customary international law, again, it's purely based on the practice of state. ILC has a very minuscule role to play in the formation of custom. So with regard to, and the other point that you raised with regard to the title, General Principles of International Law. Now, why I have taken this title is precisely because it was for the first time the ILC in its recent draft articles, I think the special rapporteur was Bermudez, was a ILC special rapporteur working on general principles of law. So the earlier conception of general principle of law was purely confined to domestic law. So if states practice a particular principle, it gets transported to international law, it becomes general principles of law. So essentially it was purely domestic in character. But for the first time, ILC in its recent report has identified general principles of international law. So in terms of international law, the yardstick is basically the UNGA resolutions, treaty, and custom, wherein you can identify general principles of international law. So when I use the term general principles of international law, I'm meaning to say not any domestic concepts which are borrowed and articulated by the ICJ, like estoppel, res judicata. All these are domestic law. So all these are general principles of law. So I'm very specific with regard to that. I'm only articulating discussing general principles of law, which in a way includes sustainable development, no harm rule, sovereignty, PSNR, etc., etc. So I'm more in terms of substantive law rather than procedural aspects. So hence I use the term general principles of international law. Yeah.
Thank you, Atul. Sorry.
I may add.
Anushna, I'm going to call upon you in a moment, and I was
Sure.
actually worried that you would finish the session without speaking at all as a co-author. Before I do that, I do want to invite one of our conveners, Swati, to make a reference for reasons I should have clarified already. She didn't think she could ask questions or suggest. So Swati, please, all the conveners are absolutely welcome to raise your hands and ask questions as well. But I believe you have a reading suggestion to make. Please go ahead and do that.
Yes, thank you, Professor Tarun. So, hello, Atul. I have a quick suggestion to make. I could not stop from making a suggestion, as sovereignty is my area of interest too. So, since you are talking about permanent sovereignty over natural resources and the dichotomy of it with that of general sovereignty, I don't know if you wish to do it or not, but you may just look at two works by Jens Bartelsson. So one would be a genealogy of sovereignty. In the chapter 2 of his book, he talks about deconstructing sovereignty. So maybe reading that would help you in deconstructing the concept of sovereignty, and then maybe you would have a new or a very interesting argument to give impetus to your dichotomy argument between these two, permanent sovereignty over natural resources and sovereignty in general. Second is again a very wonderful work by Jens Bartelsson. It is Sovereignty as Symbolic Form. So that these are the two readings that it might be helpful for you to look into these two to build upon the argument regarding sovereignty. This was only regarding your sovereignty argument in the paper, because then you're talking about Aquifers and the statist claim and the internationalist claim. So that I think these two readings would be interesting for those to build more upon those arguments. And otherwise, the paper was nice read. Thank you so much. Thank you, Professor Tarunabh.
Thank you,
so much.
Swati. Anushna, finally, we come to you.
So first of all, I'd like to thank Mr. Khaitan for this wonderful opportunity. Just a personal experience I would like to share here. So I was in my third year while writing this paper with just a course of 6 months on public international law. I could learn a lot about international law through this paper, and it has really been a matter of pleasure and a privilege to get comments from Surabhi ma'am and Tarun sir and all the other people who participated in this. A minor problem with respect to the structure and style that I faced while writing this paper, and that was highlighted by Surabhi ma'am as well, as to the clarity of the basic concepts that we are using here. So in this paper particularly, we used a number of concepts like sustainable development, good faith, and various other concepts in the passage of the paper. So what happens, very often we are unsure about till what extent do we focus and analyze those concepts such that it does not mix up or divert the scope of our paper. If ma'am or sir could elaborate a bit on it, it would be really helpful.
Well, I have a view. Let me express that, and then I'll invite Surabhi to express that too, and then we will close this session because we're getting close to the time we should end. My view is that if important concepts that are key to your argument, but the concept itself is not the object of your study, borrow. So if there is controversy over, I don't know, say good faith, I know nothing about whether it's controversial or not. If you find, you know, the two schools of thinking on what good faith means, there's school X and school Y, just tell the readers, we are going to employ good faith as understood by school X, which is, and then put that down, put in the references. In the reference, acknowledge, in the footnote, acknowledge that this is one side of the debate. There is also another view. And this can be done in the text or in the footnote, doesn't matter. Acknowledge that it's a disputed issue. I would certainly not get digressed into getting into that debate. That's not your debate, right? You need to bear a tiny burden of justification for choosing one over the other, maybe in a sentence or two. I think it's acceptable to bracket that off and say our reasons must wait for another day. Or you can say the weight of the consensus in the literature is view X, which we will adopt, even though it's been challenged by some people, which offer view Y. So you can go by that. So I would give some justification for it, if you can do so quickly, unless the view you're adopting is just completely out. So the burden of justification depends on the claim being made. If the claim is mainstream, the burden is lighter. If the claim is extremely controversial, the burden is heavier. If the claim is outlandish, you bear a very heavy burden, right? So you can do the borrowing, but you have to borrow a mainstream scholarly view, and then footnoting will suffice. This is my view. But Surabhi, do you want to jump in on this?
Yeah, I agree with that. I think, so the thing is, there's a difference between clarity in when you're researching and thinking about something versus deftness in writing, right? So it is important that you think about the concepts and the language you're using when you're preparing to write. And then when you're writing, it's exactly as Tarunabh says, you have to make choices all the time, right? There are some things that deserve time, attention, unpacking at length. Other things can be dealt with deftly. And that really has to do with, you have to decide what is the spine of your paper, right? And think about, and then what is relevant for you to then, how you need to flesh out the paper has a lot to do with where you decide the spine lies, right? Because the paper is built around the point you're trying to push, which means some things you will be exploring at much greater length, some things you'll be getting through quickly. One of the things that emerged actually in terms of the spine of your paper in all the discussions and comments is that one thing the paper can do, and I think it's a relatively easy thing for you all to do because you've talked about this already, is really the setup of the paper, right? So that you can do much more by bulking up what it is, why it's important to do this, write this paper, right? Why is this paper significant at this point in time? What is left unaddressed? And also, what are the problems or what are the challenges that confront the legal treatment of transboundary aquifers? So setting up both why you're writing this paper and what are the problems, that is, it's work that you already do to some extent, but it's come through, I think, in the comments that contextualization of your project might be very helpful for the reader and relatively easy for you to do.
Well, thank you very much, Surubhi. Hopefully that, Anushna, that gives you some instruction on how to go ahead. So thank you all for joining us. I just want to say two things before closing. First is to signal the December workshop. That's most likely going to be on a paper on the governor's powers in the Indian Constitution to choose discretion to choose to invite a leader to become chief minister in case of a hung assembly. So as we know, that's very controversial. So that's the paper we will discuss, but more details will follow on our mailing list as always. The second thing I want to say is that mimicry is the best compliment. So, you know, this is one space. It's nearly not enough to fulfill the needs of as vast and complex a region as South Asia. Please start faculty workshop spaces in your own institutions if you're based in South Asia, and you know, more the merrier. This is as you've noticed, hopefully we cannot do enough of this, and this is a resource that you need, a culture that needs to be built. And the third is, if you would like to get more involved in the Junior Faculty Forum, in its administration and its organization, please write to me. It's not something I want to do for life. I would very much like to make it sustainable and self-sufficient and then move on to other things. So please write to me, please be in touch. And I would just like to end by thanking the authors for being such gracious authors and accepting the comments, and to the discussant for being just absolutely fabulous. So thank you all very much and see you in December. Bye-bye. Oh, also to our conveners, right? Swati, Jay, and Animesh. Thanks. A video will be up